everyone for joining us. So almost exactly a year ago, though I'm sure it feels like, 20 times as long, the COVID-19 pandemic upended our lives. After the first cases were reported here in the US, the virus spread rapidly and efficiently, exploiting the fault lines of existing systemic inequality that so many of us are aware of and serve clients who are trapped in. Our public health systems and our prison systems have both been revealed as sites of extraordinary vulnerability for many system-involved people, for many poor communities, and for communities of color. Data has clearly shown that certain poor communities and communities of color are disproportionately likely to contract the virus and die from the virus. And as often happens in response to institutional or systemic bias, instead of taking to task the many externally engineered social realities that make these communities more vulnerable, individuals in these communities have been blamed for their own vulnerability, for having an underlying condition, for not taking care of themselves well enough, for somehow courting health problems through irresponsible decision-making. And then this summer, spurred by the death of George Floyd as the latest in a long line of Black men, women, and children who were shot by the police, more than 15 million people marched in big cities and small towns all across the world, with more than 500,000 people in 550 cities across the United States protesting on a single day. These protests have led to many local, state, and federal actions against police brutality and racial injustice. They have also created a space for a national discussion about shifting resources from policing into community-based networks and solutions that would provide mental health care, job training, counseling, and other holistic resources. And these protests have also created a space for a long overdue national discussion of the lingering impacts of systemic racism. Since the summer, we have had a change in our federal administration, a violent attempt to keep Congress from certifying the electoral votes installing the newly elected president, and continuing, and I'll say, and all the chop that created. But the focus on both COVID and the lingering ills of systemic racism have continued. President Biden listed, quote, a once in a century virus and, quote, a cry for racial justice, some 400 years in the making, among a list of the existential threats to our country. In 1995, in his influential Yale Law Journal article, Professor Paul Butler actually compared racism to a virus. There was an article that was advocating race-based jury nullification. Arguing the pervasiveness of systemic racism in our society, he carried the metaphor through, explaining, not everyone exposed to a virus will become sick, but that does not mean that the virus does not cause the illness of the people who do. The confluence of the two parts of that metaphor, racism as a virus, have created the moment that we find ourselves in now, with advocates looking to convert our current openness to possibility into meaningful change. The faculty of the Center on Wrongful Convictions work at this intersection, and they're going to talk today about how there's been something uniquely compelling about this moment that continues to make advocates actually feel hopeful, and in particular, that there's potential for new and compelling partnerships that will hopefully move all of us towards justice. So I'll give you a quick roadmap. After brief introductions, each panelist will speak about some of the work the center has been doing, and then I'll pose a few questions to the panel, and if there's time, we'll take questions from the participants. So if at any time you have a question, please feel free to put it in the chat. First, you'll hear from Professor Laura Nirider. Professor Nirider is a co-director of the center, and her clients have included Brendan Dassey, whose case was profiled in the Netflix global series Making a Murderer, and Damien Eccles of the West Memphis 3, whose case was profiled in the documentary West of Memphis. Then you'll hear from Professor Andrea Lewis. Professor Lewis's research interests include the various factors that contribute to the wrongful convictions of women. And she will talk about her work heading up the Women's Defense Initiative, which is a CWC project that focuses on and helps develop expertise in the issues that wrongfully convicted women face upon re-entering society. And Professor Steve Drizin, who's a co-director of the CWC, will run the anchor leg, and he'll discuss his work on felony murder and some of the partnerships that have led to exonerations of longtime CWC clients. And so with that, I'm thrilled to turn it over to Professor Nirider.
Thank you so much, Robin, and thank you so much to everybody for coming today in a strange virtual setting perhaps, but an exciting setting nonetheless. So I'm just happy to be here to talk to all of you. Robin, I couldn't agree more with you. This is a moment in time that we are in, a strange moment, a challenging moment on so many fronts, but also a moment that is laden, I think, with potential for new big ideas, for new impact beyond what any of us could have imagined before, and the potential for drawing new conversational partners into the space in which we all operate. And that's the exciting potential that I feel, despite the difficulty of this moment in which we find ourselves. So just to give you a little bit of a roadmap, building on what Robin already said, Professor Lewis and Professor Drizin are going to talk a little bit in a moment about leveraging this moment along with our students on behalf of particular clients, our individual clients who remain at the core of everything that the Center on Wrongful Convictions does. But I want to talk for a moment more broadly. I want to talk about how we at the center are using this moment as a moment to galvanize impact, to spread our impact, to build partnerships like never before, to take advantage of this moment that we're in. Of course, if you're here, you very likely know the history of the center. We've been around for 20 years. And over the course of that 20-year history, the center and our students and our partners have exonerated more than 40 innocent men, women, and children, and secured the release of dozens more. We're one of the oldest and most successful innocence clinics in the country, and very proud to have done that alongside now a generation of alumni. The work that we've tackled this past year, some of it begins in Minnesota and sprang directly from the George Floyd tragedy, murder that happened in Minnesota. There's a parallel case in Minnesota to the case of George Floyd, a case that is understood very much by the local community there to be entangled with, or sort of the spiritual inheritor of the tragedy of what happened to George Floyd. It's the case of a young man named Mayan Burrell, who 18 years ago was a 16-year-old Minneapolis resident, an African-American man, a teenager, who was accused of a very high-profile murder that happened at the time. This was back in 2002. Mayan was convicted at age 16 of participating in this murder based on the testimony of a number of jailhouse informants, some of whom received sentence reductions up to 75% of their time was shaved off in exchange for their testimony against Mayan. And at age 16, Mayan was sentenced to life behind bars for this locally high-profile shooting. The case has been one that we at the center have been aware of for many years, because it has been a case that Mayan and his family have reached out to us about for many years, asking for help. And finally, a moment in time arrived for Mayan this past summer. After the tragedy of George Floyd, the Minneapolis legal community, the Minnesota legal community, and the communities of color there were very activated around Mayan's case, seeking a solution, seeking a way to use this moment of injustice and tragedy to bring about real justice for someone else. And that was a moment that we at the center recognized. Our students had already done a deep dive into Mayan's case, into the facts of the case, into the legal chances that he had, and understood the case to be procedurally barred, perhaps in court. You know, this is not a case that we saw a clear legal path forward in court. But what we did was we convened a national panel of experts. We reached out to other law schools across the country and built an independent panel of folks, 3 former prosecutors and 3 former defense attorneys, who came into the Minnesota space with the buy-in of local actors and reinvestigated this case over Zoom. So we're bringing, the former prosecutors in to talk to us over Zoom, and we're bringing in witnesses to talk to us over Zoom, and took a deep dive at this case in the context of George Floyd and the fact that there was political will in Minnesota to do something to address this rift, this obvious and long-standing rift that had existed there between communities of color and the Minneapolis Police Department. One thing that we learned was that Maya and Burrell's alibi in this case was Cup Foods, the same convenience store outside of which George Floyd was killed, which is one reason this case is seen as a sort of inheritor of George Floyd. We reinvestigated this case. We worked closely with local actors. And at the end of the day, we were able to issue, at the end of the calendar year last year, a report recommending Maya and Burrell's immediate release from prison. That report was acted on in December of this past year, December 2020. There was a clemency hearing held by the Minnesota governor and other authorities in Minnesota. And relying on our panel's report and our expertise, Maya and Burrell's sentence was commuted to time served. He had served 18 years in prison, and he was released that same night into the arms of many members of the Minneapolis activist community of color members, which was an incredible thing. It was covered in the national news. And it was the first commutation in a murder case in Minnesota in 22 years. These are the kinds of results and conversations and partnerships that we can build on in the wake of these new conversations that were happening. Flowing from that, the Minnesota Attorney General, Keith Ellison, is now building a conviction review unit, a statewide conviction review unit. This is a systemic structure built into the prosecutor's office in Minnesota to review wrongful convictions across the state and to review cases of oversentencing across the state. So we were able to bring this national coalition of experts together, work with folks on the ground, not only to do individual justice for Maya and Burrell, but then to create a systemic office which will be able to handle these types of cases and address these kinds of injustices on a going forward basis. So that's a really concrete example of what we at the center have been able to do in the wake of George Floyd and these important, crucial conversations that we're having around racial justice and injustice in the criminal legal system. I'll be really brief with the rest of the outreach, but it's also exciting. We understand this very much to be a moment too of public outreach. There are people who are drawn to this conversation who have not been before. So we've been very active in the media, telling stories of wrongful conviction, telling stories of racial injustice, and drawing in new partners that way. Steve and I host a podcast on false confessions that when we released it in spring 2020, went to the top of the Apple podcast charts because there are folks around the country who just want to hear these stories of wrongful conviction and learn what they can do to become involved. So that's been a wonderful way in which our educational mission here at Northwestern Law School is spreading now beyond the law school itself and into the public. We're building out our social media presence. If you don't follow the Center on Wrongful Convictions, you are now missing out. So we are active now, both on Instagram and Twitter. And I encourage all of you to follow us there because we're always rolling out exciting news. And it's also a moment for a big tent partnership, right? We're doing this active work in Minnesota with affected communities. We are doing a lot of storytelling and engagement through the media, and we're building real partnerships with new kinds of partners. We're building partnerships with law enforcement agencies, law enforcement trainers who work with us to learn from these cases of wrongful conviction, to change the way that cases are being investigated so these cases don't happen so much any longer. We're working closely with corporate entities. We're so proud of the relationships that we're starting to build, not only with law firms, of course, the relationships there we cherish, and we just build off those relationships in the work that we're able to do with our students and with our clients. But now we're bringing in corporate partners too, unexpected allies who want to be part of this conversation around racial justice and what we all can do in our own ways to partner together to engage around these crucial issues and to drive the conversation forward. So it's a very active time for us at the center. I will now turn it over to Andrea, who will give you a great example of one corporate partnership in particular and the new and exciting things that we're able to do with those kinds of relationships. Thank you all for being here again, and we look forward to the conversation.
Thank you, Laura, and thank you all for being here. My name is Andrea Lewis, and I'll talk a little bit about my work and what it has looked like since the pandemic began. We just talked about, or you just heard about, how difficult the pandemic made, not just life, but also our legal practice, and how difficult it made things for our clients who already were facing a tough situation in prison. And at the Center on Wrongful Convictions, our clients are generally actually innocent or overcharged or over-sentenced. And with the shutdown of courts, a lot of their proceedings, because they had already been convicted, were moved to the back of the line. So one thing the pandemic did was allow us to become more creative and allow us to decide what more we can be doing from this space at Northwestern Pritzker School of Law. And so with that, as Laura mentioned, it was a perfect time to think about racial justice. It's also a perfect time to think about justice with regards to sex and gender. And so I have been working on the Women's Defense Initiative, which will be launching this fall. Many of you on the call may have worked with or known Karen Daniel and Judy Royal, and you know that they started a women's project a few years ago, and I actually came into the Center on Wrongful Convictions under that project. Now the center, over its 20 years, has been successful in gaining release of women. 7 Center on Wrongful Convictions women clients have been freed or exonerated to date, including one who was freed last month. And that's really important because fewer than 10% of the people on the National Registry of Exonerations, which is how we generally track these exonerations, are women. And so the center has done fairly well in that space, including, just to give you an example, there's a client, Tina Jimerson, who was exonerated just last year, and she was one of just 9 women in the United States who were exonerated in 2020, and only 3 of those women were exonerated after facing convictions of murder, and Tina had been convicted of murder. And I talk about Tina's case because it brings in all of the issues that Robin was talking about at the beginning. It brings in issues of race, it brings in issues of poverty, it brings in issues of sex. Tina and all of her co-defendants were, fairly poor and in a rural town in Arkansas. They were all Black, and they had been rounded up for the murder of a white woman in town. Tina herself was a victim of sexual violence, and she became a suspect after she tried to report her rape to the police. She got caught up wrongfully in the criminal justice system and was completely disbelieved, right? And so her case, at least to me, was a perfect example of the issues, some of the issues we were seeing with regards to women here in the center. One, there are not that many women exonerees compared to men. Like I said, they make up fewer than 9%. And 2, Tina was one of the lucky ones. A few of our, at least a couple of our clients, they've been freed, but they'll never be exonerated. And we receive a lot of letters from women who have faced wrongful convictions who, for whatever reason, much like Laura was talking about, may not have a path back into court, but they shouldn't be sitting in prison. Another thing that I was seeing, racial disparities when we're looking at exonerations. Over half of the women's exonerees were white, despite the fact that more women of color are in prison. And the imprisonment rate of Black women right now is almost 2 times the imprisonment rate of white women, so that's changing a bit over time. Some things we're also seeing are overcharging. So women may be charged with murder in a case where we may think they did nothing wrong, but at best, for instance, if a child was injured, they should have been charged with neglect. We see a lot of cases of oversentencing where judges make comments about womanhood or make comments about motherhood and add on time to the sentence, apparently because of that. And so all of these issues, we felt like we need to deal with this, and the actual innocent space maybe doesn't create a path for many women. And so with that, I wanted to essentially bring a women's initiative into line with what Steve and Laura, co-directors, have been doing for years, and essentially reclaim and embrace the term wrongful convictions in our name. And so in addition to working on actual innocence cases, I'm now working on resentencings. I'm working on petitions for executive clemency, for sentence commutations. And as I mentioned, one of our clients, LaToya Griffin, was released just last month after receiving a sentence commutation from the Illinois governor. I'll be directing litigation with that project. Sarah Somervold here in the center will be the associate director. And we have been able to get off to a good start with partnerships, as Laura mentioned. PepsiCo just recently gave us a fairly large amount of funding for an additional attorney who we hope to hire this summer. And we also hope to have an ongoing relationship with PepsiCo through their volunteer initiatives as well. And so we've always worked with law firms. We will continue to work with law firms. But as Laura mentioned, being able to branch out and partner with the general public and with corporate sponsors as well is a pretty exciting new turn in the Center on Wrongful Convictions. Of course, students have been working with us on all of our cases, and students have been working on women's cases excitedly as well. Two of my students essentially walked LaToya Griffin's case through the executive clemency process. Students worked with me on Tina Jimerson, and they work with me on all of my current cases moving forward. And so the center really is in a good position to help other organizations in the Innocence Network grapple with what to do with wrongful convictions where actual innocence is difficult to prove. And I'm proud that we've been at the forefront of this process and that we'll continue to be at the forefront of that. We're here to help the practice evolve. And speaking of helping the practice evolve and expanding the definition or embracing the term wrongful convictions, I will pass things over to Steve to talk about felony murder. Steve, you're on mute.
Okay. It's a pleasure to be here today. And it's a pleasure to follow both Andrea and Laura. And I want to tell you about the work that I've been doing since the pandemic hit. And it's work that's been a long time in coming. I remember maybe 10 years ago or so, a law professor who's a friend of mine, a criminal defense lawyer, wrote an article called "In Praise of the Guilty Project" or something along those lines. And she was concerned about the way in which the innocence movement was getting a little bit too full of itself, if you will. Talking about itself as the sort of new civil rights movement or the greatest civil rights movement since the 1960s, or the greatest human rights movement since the 1960s. And she took the movement to task for that kind of language because when push comes to shove, the innocence movement has been a significant movement to drive criminal justice reforms that affect both the innocent and the guilty, and to enhance the due process rights of criminal defendants. But in the grand scheme of things, it only affects a very small pie of the millions of people who are locked up in the United States on a daily basis. It does little to make any dent in the mass incarceration problem, and it also does little to deal with issues related to the death penalty. And I was growing increasingly frustrated with the innocence movement. Now, since I've done innocence work for the past 2 decades, I've always made sure that my students work on cases involving people who have been convicted. And I've used the clemency process to have them establish relationships with people who are serving 15, 20, 25, 30, 50-year sentences to try to get them out of prison through the commutation process. And I decided in the wake of the murder of George Floyd and what looked like a real civil rights movement, that I was going to expand my work into this space, into this clemency space. And the beauty of the Center on Wrongful Convictions is that it's not called the Innocence Project, and it can include wrongful sentencing as well as wrongful convictions. And my focus became on felony murder cases, in particular, felony murder cases where police officers shoot and kill one of the co-felons, and the surviving co-felon is charged with the murder of his friend and accomplice. Let me tell you a story. Two young men come up with a harebrained scheme to rob a man in his home of boxes of cologne that this man sells in a local flea market. It's not a very well planned out plan. These young men get a pellet gun that's unloaded. They dress themselves in yellow ponchos with scarves. They walk up to the home in the middle of the day and they knock on the door. And when the woman of the home answers the door, they force themselves into the home and start asking about the cologne. The best laid plans go awry almost immediately. Out of the corner of my client's eye, he sees the owner of the home, the person who runs the cologne business, swinging at him with a mop stick. And he decides, this is more than I bargained for. And he and his friend decide, we got to get out of here. And so they quickly turn around and they flee the home. Now, unbeknownst to them, the homeowner has a son who's moved in the basement, and he's living in the basement. And that son is an off-duty Chicago police officer. And he hears the commotion and he comes upstairs and he picks up his service revolver with him and he runs after the men in the street as they're running away from the home. And he starts opening fire. And he fires 8 shots in their direction. He shoots one of the men in the hand, my client, and he shoots the other man in the back. And in this fusillade, he even ends up shooting his own father, who got in the way of some of his shots. My client drags his friend into his car. They speed away from the scene, and my client is arrested when he goes to the hospital to get treated for a wound in his hand. His friend, who was only 14 years old, was killed by the bullet that was shot by the police officer. And when he is arrested, because the police are notified by the hospital that someone has been brought in with a gunshot wound, he finds that he is being charged with felony murder for the death of his 14-year-old friend. And this is what happens in Chicago. This is what happens in Illinois. Immediately, used to be a man named Pat Camden, who was a spokesman for the Chicago police officers, arrives at the scene, tells the story of the shooting in a way that makes the police officer look to have been justified in the shooting and to have been a heroic cop. Why did he shoot the 14-year-old boy? Because according to Pat Camden, the boy had turned around and assumed a shooter's stance in the direction of the police officer. The cop is lionized in the press. My client is charged with felony murder. But a funny thing happens on the way to the felony murder conviction. Turns out that the 14-year-old boy was shot in the back, not in the front. There was no shooter's stance. Even the shooter himself, the police officer, said he never saw a gun in the 14-year-old's hands. Nevertheless, under Illinois' felony murder law, my client is convicted of first-degree murder. He really has no defense because it doesn't matter if the police officers are an intervening or supervening cause, as long as the original felony set in motion a course of events which leads to a death, whether it's accidental or intentional, whether it's committed by a third party or by one of the co-felons, he can be charged and convicted with felony murder. And he's sentenced to 40 years in prison. Now, it turns out this wasn't the last time this police officer made the front page of the Chicago Tribune. A few years later, we learn that he himself has been arrested for the premeditated murder of his wife and the attempted murder of his mother-in-law, who who intervened in a domestic dispute and was stabbed in trying to defend her daughter. For that murder, that premeditated murder, that police officer got 25 years in prison. For the felony murder, my client got 40 years in prison. Since the pandemic hit, I have been representing numerous defendants charged with felony murder in cases in which co-felons have been killed by police officers or third parties. All of the defendants in these cases are African American or Latino defendants. In most of the cases, the police officers are white police officers. And in my client's case, the family of the 14-year-old filed a civil rights lawsuit against the police officer who shot and killed the 14-year-old boy. And a civil jury found him 80% responsible for the death and the shooting to be unjustified. But none of that serves as a defense in the criminal case of felony murder. I've represented 5 defendants on felony murder or accomplice liability charges since the start of the pandemic. And I'm representing about 15 or 20 of these defendants, but 5 of them have been granted commutations by Governor Pritzker since the start of the pandemic. And it's given me and my students an opportunity to educate the public about the unfairness of Illinois' felony murder rule, to work with legislators in an attempt to reform the felony murder rule, to speak to legislators, to write letters of support, and to give my students client contact in a real way, even if it's only 30 minutes a shot by phone every couple of weeks, that they could not get in cases with their wrongful conviction clients when the courts were shut down. And I hope to expand my work in this area and to do more work in the commutation and clemency space so we can make a bigger dent in the mass incarceration problem in Illinois and beyond Illinois. I'll turn it back to Robin.
Thank you. And now I have a few questions for the panelists, though there was a comment in the chat asking if someone would discuss the effect of EDPA. Do people still say EDPA? When I was working on it like a billion years ago in law school, people said EDPA, but the effect of EDPA on wrongful convictions. And but I'm hoping that Professor Nirider will address that issue in the context of discussing how this moment is different and what's different about this moment and why, and are we in the middle of a movement? So Professor Nirider.
Thank you so much, Robin. And thank you for the question from our audience member about EDPA and wrongful convictions. EDPA, yes, I think, Robin, people do still say EDPA or AEDPA, which is the Anti-Terrorism and Effective Death Penalty Act, a federal law that was passed 25 years ago in 1996 at the height of the mid-90s tough on crime era, born of fears about super predators and rising crime rates, and a sense at the time that what needed to be done was to take people who'd been convicted of crimes and lock them away and throw away the key. And in the eyes of the folks who crafted EDPA, hasten their path to the execution chamber for those who'd been sentenced to death. The intent of the act was to streamline or to eliminate parts of the appeals process, to make it much harder to appeal on behalf of individuals who'd been sentenced to death, yes, but also any convicted individual who sought relief in federal court. Of course, like a lot of criminal practitioners, we've contended with EDPA for a long time, right? It's been in place for 25 years. We have won exonerations and our students have won exonerations in cases that go to federal court despite EDPA, right? In the case of clients like Melvin Newman or Nicole Harris or Daniel Taylor, which is a point of pride because EDPA has made the availability of relief vanishingly rare in federal court, right? If you have a client who's convicted in state court, you can appeal their case through the state court process. If you lose there, you have the option of bringing his or her case to the federal court system to seek relief there. But thanks to EDPA, thanks to the almost impossible to meet standards for relief that law erected 25 years ago, more than 99% of cases are denied under EDPA, including cases of patently innocent people who have gone on after losing in federal courts, who have gone on years later to find some other way of proving their innocence, whether by forensic testing or otherwise. EDPA is a law that has denied justice to many, many, many thousands of state defendants who take their cases to federal court, the innocents and the guilty alike, all of those who are deserving of one form of constitutional relief or another. This is an artifact, as I said, of the culture of the way we thought about crime and punishment 25 years ago. And I am pleased and proud to report that after these 25 years have passed, we are starting, I think, to learn collectively as a nation. Again, we find ourselves in this moment of time when new conversations are emerging about all of these sometimes obscure structures in our legal system that in fact erect enormous substantive barriers to justice, whether it's the felony murder rule or EDPA or any host of a number of other barriers that are baked into the system and that can be almost invisible to people who aren't practitioners. So right now, for example, for the first time that I've seen in quite some time, there is real conversation in this country about addressing EDPA, about making federal habeas relief more accessible, about opening the doors of the federal courts to defendants who want only a chance to plead their best case, who only want a chance to be heard. There's been a series of op-eds recently published in the Washington Post by Radley Balco, who's one of their regular contributors. He's releasing a series of articles criticizing EDPA, pointing out how it has obstructed the exoneration of innocent people, how it's led to serious injustice in other cases. So I encourage you to just go ahead and Google Radley Balco and EDPA and Washington Post, and you'll see these articles pop right up at the compelling stories of injustice that they tell. There's conversation among politicians and leaders in the legislative space about revisiting laws like these, like EDPA, about revisiting this old way of thinking due to the fact that we now understand that this thinking from 25 years ago, lock them up and throw away the key, is no longer how we do things. And it should never have been how we do things. And the Center on Wrongful Convictions is very pleased to be a part of those ongoing conversations among senators, among congressmen, and among leaders in the space across the country, from the federal defenders to the capital defenders to the innocence community to impacted people themselves, around what can we do to open the doors of federal courts. So that's EDPA in a nutshell. It's highly problematic, but finally there's new energy around revisiting it. In the meantime, of course, what you're hearing us talk about today is what we're doing because EDPA still exists and makes it difficult to get relief in federal court. There are other avenues for relief for our clients, like clemency, and that's the incredible work that Andrea and Steve have been doing in bringing these cases to governors and elected officials to seek justice that way, until we can make the courthouse doors more open and more receptive to these valid claims for relief. And I will point out, it's not just EDPA, there's so much energy around legislative reform in general right now. That's part of what's really exciting too. I'd say in the last 3 weeks, maybe, Steve, we've testified in support of 2 bills, one in New York and one in Maryland and one in Oregon. The Maryland bill would, for the first time, require lawyers for kids being interrogated in police stations, right? In most states around the country, your child can be brought in and questioned by police without you, a parent, even being notified, let alone the presence of a lawyer. Maryland's trying to change that, and we are proud to testify in support of a bill that would require lawyers for kids in the interrogation room. In Oregon, it's another form of really exciting reform being proposed there. There, it's a legislative bill that would ban deception in the interrogation room. Lying during interrogations is legal in the United States, even though many, many other countries across the globe have prohibited the practice because it's such a risk factor for false confessions. So we testified in support of a bill in Oregon that would ban lying about interrogations. We're participating in legislative efforts here in Illinois, in New York too, around similar measures. So Robin, yes, it's a moment that we're in. There is so much will to make change. There is such a shift in our thinking from the past 25 years. And we are just so grateful to folks like you who have been through law school, who we know care deeply about these issues and want to steward them alongside us. So please do, again, follow us on social media so you can learn more about this work that we're doing and how to get involved and support it.
Thank you. So there's a question in the chat about horizontal deterrence, but I think we can get to that question in just a bit, because we did want to talk a bit about some partnerships within the Bluhm Legal Clinic that have benefited CWC clients and students. So if any of the panelists can take that question to discuss some of the partnerships that have benefited CWC students.
So I can start really briefly within the Bluhm Legal Clinic. And I'll just talk about, especially since the pandemic and since, fashioning this new project moving forward, I've done a lot of cross-clinic collaboration, which I think is extremely beneficial to students. So I'm working on a case with the Children and Family Justice Center. I'm working on a case with the Center for International Human Rights. And so students, in addition to being exposed to different instructors from different clinics, are also learning different areas of the law, right? And their colleagues working on Center on Wrongful Conviction cases also are learning more about wrongful convictions and more about criminal post-conviction work. And so partnering within the Bluhm Legal Clinic in that way allows our students to become more well-rounded attorneys and exposes them to different practice areas that they perhaps wouldn't have been exposed to had they not taken clinic and had they not worked in a clinic where we're a collaborative space and where we work with our colleagues extensively. I also know I'm always amazed at my colleagues who bring in outside speakers or put on, different panels and things so that I can learn and I can become a more well-rounded attorney. And so that is probably the way that impacts me the most and impacts my students the most as far as partnerships within the Bluhm Legal Clinic.
Okay. And how about partnerships outside of the Bluhm Legal Clinic that have benefited CWC clients and students? Professor Drizin, do you want to take that one?
Sure. One of the most interesting and fulfilling parts of being at the Center on Wrongful Convictions and frankly being at the Bluhm Legal Clinic is that we get to partner with many of our former students on a regular basis on cases. These cases take a long time to resolve, the wrongful conviction cases, sometimes a decade or more. And many times our students go out into the workspace working at local or national law firms, and they want to maintain their work on a case. That's what Laura did with the Brendan Dassey case. And then she came back to Northwestern and worked on a case. So we have a lot of partnerships with private law firms and with former students on active cases. But we also do a lot of partnering with sort of unusual suspects, if you will. In the interrogation reform space, we have developed a partnership with one of the leading trainers of law enforcement officers in interrogation practices, Wicklander and Zulawski. They even wrote and signed an amicus brief in Brendan's case when we tried to get the US Supreme Court to take the case. Just last week, the president of Wicklander testified in support of a bill aimed at providing counsel for kids in the police station and for banning deception in interrogations of children. And we frequently partner with groups who are in the world of the arts, whether it be documentary filmmakers, podcasters, and playwrights to promote our work and to promote the issues that we care deeply about. So there are a lot of fascinating partnerships outside of the clinic that we have forged and will continue to forge.
Great. Professor Drizin, do you want to segue into the question in the chat? The question is, does the concept of horizontal deterrence i.e. that the prospect of severe punishment of potential felons no longer apply in criminal justice? If criminal conspirators can be immune from the consequences of their plots, have we done away with the Pinkerton doctrine?
As far as I know, we haven't done away with the Pinkerton method, and the laws of criminal conspiracy are still present, just as the laws of accountability are present. Part of the reason why I've looked at felony murder as opposed to that area of the law is because in most of the cases that I work on, the reason they are bringing felony murder charges is because they can't make the case that someone is accountable under a conspiracy theory or an accomplice liability doctrine. So they rely on the felony murder rule to solve issues, thorny issues of criminal intent, because all you need to have proven is that someone had the intent to commit the underlying felony and not any higher level of intent with regard to the consequences of the felony. So those laws still exist. Whether or not they work as a principle of horizontal deterrence is a debate that we can have some other time. It could probably take up hours, but I don't believe they deter.
All right, so so here we reserved a few more minutes for questions from the participants. So if you have any questions, please do feel free to put them in the chat. But in the meantime, I would love to ask any of the panelists to talk about some of the amazing victories you've had recently. In particular, I'm thinking of the Wayne Antousis case. If somebody wanted to sort of talk about that, which is I think a case that the clinic has had for such a long time that many people who are dialed in might have at some point worked on it. And it also is a great example of interclinic collaboration and some really, I'll say, some pretty fancy legal footwork. So any of the panelists can take that one.
Anybody? I'm just trying to get the stripes off my face here. So the Wayne Antousis case was a case involving multiple teenagers who were charged with the double murder of two teenage girls who were shot in connection with a gang retaliation shooting. At least that was the police theory of the case. Everybody knew who the shooter was from the very beginning of the case. It was a 15-year-old boy who was sentenced and convicted of the murder and sentenced to an extremely long sentence. But the real question was, who were the accomplices and what role did they play in the crime? And Wayne Antousis was 17 at the time and was not present when the shooting occurred, and always maintained that he didn't have any role in the planning or the solicitation of the acts that led to the girl's death. This was a sort of instantaneous decision made by a 15-year-old impulsive boy that happened, and the police officers simply expanded the pie to include a number of other defendants. And the case was fascinating because it involved working with members of the Children and Family Justice Center, because Wayne was sentenced to the equivalent of a life sentence at the age of 17. And so there was a resentencing hearing for him after the US Supreme Court had granted relief in Miller versus Alabama and gave new sentencing hearings to people who were sentenced to life without parole as juveniles. And that was a case that involved members of the CWC, members of the criminal defense team at the Northwestern and also members of the CFJC, the Children and Family Justice Center. And we were able to get Wayne's sentence commuted to a much more reasonable sentence. But Wayne's innocence still needed to be litigated. And Greg Swigert from the Center on Wrongful Convictions and Judy Royal, who used to work at the Center on Wrongful Convictions, were really the champions of Wayne's innocence claim. And over the years, several of the co-defendants who had testified against Wayne in exchange for sentence reductions of their own had recanted their testimony and been told that they were plied, that their testimony was plied with promises of leniency and a whole host of privileges, including visits with girlfriends and the ability to view pornography, and specialized treatment within the Department of Corrections in order to get them to implicate Wayne Antousis. Members of the CWC staff did a thorough investigation of this and discovered that a lot of this information was never disclosed to the defense team, giving us another way to attack the conviction itself. Andrea, you want to take it from there, how the case was resolved?
Yes, though the resolution of the case was messy, as Steve mentioned. So Wayne Antousis' co-defendants received post-conviction relief first. And unfortunately for Wayne, although the state essentially agreed to dismiss the charges when they arrived in court, the trial court judge essentially said, you two don't get to decide whether his charges should be dismissed. I'm the one who gets to make that decision. Please go write me some briefings on why you think I should make that decision. And so they did. And then they came back to court and the judge dismissed Wayne Antousis' post-conviction petition outright. So denied him relief, said, please, no, you can't have any relief. And so Wayne was stuck having to file an appeal of his case. And so Greg and his team did file that appeal. They did so along with the state's attorney's office, who was cooperative through this process. And they ultimately were able to go in and tell the appellate court, hey, we believe that these charges should be dismissed. So would you please direct that Wayne's charges be dismissed? So they were. And he was released very recently from prison and is doing well. And he is our most recent exoneree, and we're so happy that that result came about, although not as happy that it took so long and involved so many twists and turns.
And I don't know if you, one of the common denominators between the Wayne Antousis case and Professor Drizin, the case that you spoke about, is the youth of the defendants. And so I don't know if anyone perhaps wants to talk a little bit about how, recent, but not that new anymore, advances in adolescent brain development affects the work that the center does. And it actually is also responsive to the question about the Pinkerton Doctrine as well.
Yeah, I'd be happy to talk about that. You know, up until a few years ago, there were actually two very closely related centers at Northwestern Bluhm Legal Clinic. There was the Center on Wrongful Convictions, and there was the Center on Wrongful Convictions of Youth, which was a sister project with separate funding, separate faculty, but a very similar mission. The mission was to investigate cases and exonerate young people, children and adolescents who'd been convicted of crimes they didn't commit, and to seek systemic reform around the ways in which young people interact with the criminal legal system. There was a moment in time then too that is, I think, crescendoing and building to the moment that we find ourselves in. There had been a massive effort, thanks to the work of advocates around the country, including Steve, to develop research around adolescent brain development, right? To understand why it is teenagers are these impulsive beings that we all know them to be, right? As a matter of common sense in our own personal experience. And it turns out that when you look at an adolescent's brain and the stage of development in which they find themselves, in which any teenager finds him or herself, the prefrontal cortex, right, which is right underneath your forehead here, that's the part of the brain that acts as a brake on decision making, that regulates your judgment, that weighs long-term risks against short-term benefits. This particular part of the brain, the prefrontal cortex, is one of the later parts of the brain to develop, right? And this is the part of the brain that's about judgment. So when you see a teenager speeding down the road, breaking the speed limit, popping the top of the car and cracking a beer while they're driving, doing something insanely irresponsible, you can attribute that to the prefrontal cortex, right? Those questions of judgment about weighing of risks, they're just not developed yet. And that is true categorically for any teenager across the board, right? Regardless of color, class, wealth, status, privilege. That is true for everybody. The US Supreme Court recognized this thanks to the work of advocates around the country in a series of rulings that took this adolescent brain science into consideration when asking questions about, well, how do you punish someone who's 13 or 14 or 15 or 16 who does something colossally stupid, right, and damaging? How do you think about properly punishing someone like that who will necessarily grow and develop past that teenage moment of impulsivity and poor judgment and poor decision making? Though that series of cases, which unfolded from 2005 until really just a few years ago, one by one systemically eliminated certain types of punishments that kids could get. The first one eliminated the juvenile death penalty. This is in 2005. Until 2005, children and teenagers in this country could still be sentenced to death. That was eliminated in 2005 under the idea that all children are capable of redemption. All children are capable of growth and a future and growing past this thing they did when they were 13 or 14 or 15. There was another series of decisions that had the collective effect of abolishing mandatory life without parole for anyone under 18 under the same set of principles, right? We cannot lock them away and throw away the key. We cannot countenance the idea that they won't get a second look at some point later on down the road in their incarceration without first taking into account during sentencing the fact that this was a child, the fact that this was a 16-year-old or 17-year-old, someone whose brain is not yet fully developed when it comes to judgment and decision-making, someone capable of redemption, someone not yet fully formed, someone in which we should systemically still have some faith, some hope in that day of redemption to come. Based on all of those decisions, there has been an absolute wave across the country addressing juvenile sentences, important new conversations about why are we punishing children so severely? And those conversations bleed over into the rest of the criminal justice system too, not just sentencing conversations. For example, in 2011, the Supreme Court acknowledged in a decision called JDB versus North Carolina that these same considerations about the juvenile brain, the adolescent brain, meant that we should be reading children their Miranda rights more often than adults, because it's that much more important to protect juveniles in the interrogation room. Again, this interrogation room where you're making decisions whether to confess or not that affect possibly the rest of your life. Kids aren't equipped to make those kinds of decisions. They need the support of additional and more frequent Miranda warnings. And the same set of considerations are what's leading to these laws that Steve and I have been talking about today. Laws requiring lawyers for kids in the interrogation room. Laws requiring police officers not to deceive or use manipulative tactics when you're interrogating children. It's an area of the law where there is so much energy around rethinking the way our system treats and mistreats children and teenagers. It's an area of the law that's captured the public's imagination, again, in Making a Murderer, the Netflix series about our client, Brendan Dassey, who was 16 years old when he was manipulated into confessing to a crime he didn't commit. You can see it in the Netflix series When They See Us, the exonerated five, once called the Central Park Five, a group of five Black teenagers who were coerced into confessing to a crime they didn't commit in New York. And you can see it all across the cultural discourse now as we are rethinking the ways in which kids interact with the justice system and the way in which we need to make the system much more protective of these most vulnerable members of our society. So it's an exciting space to be in. It's one that permeates a lot of the cases that we do at the Center on Wrongful Convictions. And I hope many more good things to come on that front.
Thank you. Okay, so we are over time, and so I'm going to thank everyone, thank all of you for coming, and I'm going to thank the panelists for their time and for sharing their experiences and for the extraordinary work that they do, both with our students and for our clients. Thank you, everybody. We'll sign off now.